right. I see some people are already logged on. If you can raise your hand in the GoToWebinar hand raising control panel. Thank you very much. We'll start in a minute. Can't hear me. Others can. So let me make sure everybody can hear me. I'm getting at least one person who says they can't. So if you can hear me, raise your hand again. If you can't hear me, then you don't no idea what I'm saying. Microphone. Oh, let me. I don't know. Seems to be working. People are raising their hand. All right. Thank you, guys. Get your audio. All right. So we're going to go ahead and get started. Why not? Where we left off last week, I guess it seems like it was a long time ago. Tuesday, right? We had talked about, just to recap, I was discussing what happens in paragraph 10A7, where it says that if you amend any of the disclosures, if you're on the seller side, it gives the buyer the right to cancel for another 3 days. Then there's in B is the section that deals with the natural hazard disclosures. And it says that the seller shall, if required by law, deliver to buyer earthquake guides, questionnaire, environmental hazards booklet, home energy rating, flood area, seismic zone, and any other zones that are required by law. So that's that package that I showed you, and we're going to go back into zip forms by the end of today. And there's a package under EPUBs where it has all this. And if I'm the buyer's agent, I want to make sure they get it. And I know the wording of it is the seller shall do it. But I give it to the buyer, and then we sign the receipt that says that they've got it. There's a withholding taxes, and there's the FERPTA form. And this is another seller shall deliver to buyer or a qualified substitute. All right, now, sometimes a listing agent will have the seller sign one of the FERPTA forms. Sometimes they don't. I generally don't do that on my own listings because the title company is a qualified substitute. And so the title company is going to actually make them fill out their form, even if you get them to fill out your form, if you understand. So all we need to do is tell the title company to give a copy to the buyer's agent if that's on the transaction coordinator's checklist. Megan's Law disclosure, you probably heard of that, and it discloses whether or not there's any known sex offenders in the neighborhood. There are other sites where buyers can get way more detailed information. If they're interested, they could look at that. The statewide buyer and seller advisory, which is something that you ought to have them read and sign, says that if they're interested in this sort of thing, that they should do their own research. Are there gas or hazardous liquid transmission lines? There's a place for them to, go and to look and see if there are any. If it's a condominium or a planned development, The condominium, by the way, would include a PUD. A PUD is a planned unit development. And the other name, by the way, for a planned unit development is a townhouse, right, where you own the land. And then there are also planned development projects, which are where you have single family homes, Santa Teresa Swim and Racket Club, Almaden Country Club, Silver Creek Country Club. These are people with single family detached homes, yet there is a homeowner association. It says that seller has 7 days is the default to disclose to the buyer of the condominium or in a planned development or other common interest subdivision. And the form ESPQ, or the seller property questionnaire, or the exempt statutory disclosures, that's the ESD form. If you're doing it right and you're representing the seller, you would have all this by the time you put it on the market. I helped an agent with an offer in an area where there was a condominium and they didn't have anything, right? So anyhow, they're supposed to tell you about this. If the property is in a condominium, this is paragraph 2, or located in a planned development, seller has 3 days after acceptance to request the HOA docs. All right, so we're going to get HOA, copies of the documents required by law, disclosure of any pending or any anticipated litigation, parking and storage spaces, copies of the most 12 months of the HOA minutes, the names and contact information, the governing property, private transfer fees. Now, in another place, paragraph 7, when we were saying who pays for what, one of the things was we could check that the seller would pay a private transfer fee. Pet fee restrictions, smoking restrictions. Seller shall, it says here, itemize and deliver to buyer all of the disclosures and any that are in their possession. Buyer's approval of the common interest disclosures is a contingency of this agreement. It's specified in paragraph 14B3. So where do we find, so let's say you've got the homeowner association documents, and if you printed it out, it would probably empty the paper and the printer, you know, you'd go through a ream maybe. Sometimes it seems like that. Well, what is it that you should be looking for if you're representing the buyer? Well, some of the most common questions that people have is, number one, can I rent it out? All right, if I buy the condominium, and whether I'm going to move in there now, maybe in the future I want to rent it out, can I rent it out? And sometimes there's no rent restrictions. You can do whatever you want. Sometimes there's a percentage that are allowed to be rented out, and you have to get on a waiting list if there are so many already rented out. The reason that they do this is because the maintenance of the facility is much better if there's fewer renters. Plus, there are lenders who, if the percentage of units are rented, will not make loans, right? They just won't make loans. Now, a lot of times agents say, well, how do I know? You know, they don't have copies of the HOA docs. How do I know if this is something where you could make loans? And what you could do is, if you go into the MLS software and you do a search for all of the listings, active, pending, recently closed, let's say the last 3 months, 6 months, or whatever, and you basically, you know, you zoom in, so you're pretty much running just that subdivision. And what you're going to find is either properties are selling and closing or they're not. And if you can see that units are selling and closing, then apparently it's probably possible to get a loan on this. If you're saying, well, my loan agent says they can't make loans on it through either Realist or RPR, you can look up and see who the lenders were for those transactions. You could call the agent, by the way, and say, hey, I have a buyer that's interested in buying, same place where you just sold the house, and we're, you know, what lender did you use? Sometimes you can find out by just seeing the ones that have closed. because obviously they had a lender. Also, you'll find if you go through enough of the units that have been for sale or are for sale, even if it's not your unit, you're going to find probably copies of the HOA documents. So you could actually get, even if they don't have them, an agent that's got a pending transaction may have them, and they're probably still available for you to download. You parking, how many parking spaces, how many pets? These are the big questions. A lot of the juicy stuff, sometimes you can find in the HOA meeting minutes, right? Because that's where they're fighting with each other and discussing things. I sold a property. I had a buyer interested in a townhouse in Almaden, and I'm reading the HOA meeting minutes, and they start talking about wild pigs, right? So there's discussions in the meetings about wild pigs, and there are apparently wild pigs running around up in this area. And as I'm reading in one of the meeting minutes, they form a wild pig committee, right? They formed a committee in the HOA, and they eventually hired a professional pig trapper. I did not even realize this was a potential career path. You know, I might have chosen that at some point in my life. And the guy had caught like a dozen wild pigs one weekend. So I'm going through and I'm marking this. And, you know, I told the potential buyer that, you know, she had a teenage son, and I told her I would get her a barbecue pit and him a crossbow, but she declined to buy the property because of the wild pig infestation. So if they're running out of money, and if they're talking about we need to replace the parking lot, the need to resurface it or do something like that, sometimes you'll find that in the HOA meeting minutes. Essentially, we give them to the buyer and they're supposed to read them, but you might want to look at them yourself. I had sold a condo, a townhouse, and in Willow Glen, and the buyer, I represented the seller, and the buyer's agent moved in. The buyer moved in and got a notice that there was an $8,000 assessment that was about to come due. And so the agent called me up and said, you know, you guys, you know, you're supposed to disclose that. You never told us. And I said, no, as the listing agent, I didn't even read the HOA documents. But I said it was in the HOA documents that this assessment was coming. This isn't that we didn't tell you, it's that you didn't read it, and neither did your client. So you understand this is something that somebody ought to look at, right? Can they rent it out? Can they have the pets they want? Is there litigation that would make it so lenders may not be happy to make a loan? Paragraph 11, the condition of the property. I see listing agents putting in the MLS property to be sold as is. Well, yeah, that's nice. The purchase contract says the property is to be sold as is. Many real estate agents, I think, don't understand what as is means. As is does not mean that the seller does not have to tell you what's wrong with the property. As is means that the seller is not obligated to fix anything at this point in time. Right now, the buyer can later ask for the seller to fix stuff. But in the old days, the purchase agreement used to contain seller warranties. The seller said, I'm going to give you a Section 1 termite clearance, a 1-year leak-free warranty from a licensed roofing contractor. Any broken and cracked glass will be replaced. All debris would be removed. Any leaks would be repaired. You get the idea. Well, we don't use that anymore. So as is means the seller is not obligated to fix anything. However, this is subject to the buyer's investigation rights. We're going to get to that. And then it says that the property should be maintained in substantially the same condition as of the date of acceptance. And debris and personal property not included in the sale are to be removed by the close of escrow. That's what the contract says. So The seller, even though it's being sold as is, must disclose known material facts and defects, including known insurance claims within the past 5 years. Now, if the listing agent is doing a good job, they might already have this. But if it's something you're concerned about, there's a report you can get, and that report is called a CLUE report, Comprehensive Loss Underwriting Evaluation or whatever. And the CLUE report will tell you whether or not there have been insurance claims in the last 5 years. The reason why this is important is because if the seller has made claims on the homeowner's insurance policy, the buyer may have difficulty getting homeowner's insurance. And if that's the case, then the buyer's not going to be able to get a loan from most normal lenders. Then it says in B, the buyer has the right to conduct investigations. And there's a whole long list of what they can be. In fact, buyer is strongly advised to conduct investigations of the entire property. Property improvements may not be built according to code. Let's look at this. In compliance with current law or have had permits issued. Yeah. So many times agents will say to me, well, I'm at the house and the house says it says in the county records that this is a 3-bedroom, 1 bath, and 1,300 square feet. But the MLS says that it's 2,500 square feet and it's a 4-bedroom or a 5-bedroom, 2-bath, or 3-bath. What's up? And the answer probably is that those were improvements that were made without the benefit of building permits. What does that mean? Well, it's hard to say. The worst case scenario would be if it was unsafe, that the city might make you put it back. But they're not going there right now, right? Unless there's something that is really unsafe, they're not really hassling people. But they should realize that if it is unsafe, the city might make them put it back to the way it was or bring it up to code. Paragraph 12 is one of the most broad ranging contingencies. It says the buyer's acceptance of the condition of and any other matter affecting the property is a contingency of this agreement. The condition of and any other matter affecting the property is a contingency of this agreement. And all of these contingencies are pretty much, except perhaps appraisal and loan, tied to paragraph 14B, which we're going to get to. And then it says buyer shall have the right at buyer's expense to conduct inspections, investigation, tests, surveys, and other studies, including but not limited to. And then it goes on with a long list. Physical inspection, wood destroying pests and organisms, any inspection for an any inspection for wood destroying pests and organisms shall be prepared by a registered structural pest control company, shall cover the building and attached structures, may cover detached structures, shall not include water tests of shower pans on upper levels unless the owners of the property below consent, and shall not include roof coverings. Right? It's just what it says. That's talking about the termite report. If it's in the condominium, the inspection shall include only the separate interest and any exclusive use areas, not the common areas. You could inspect for lead-based paint if you want to. I actually have a business card from people that go out and do that. I've never had a client want to, but you could. And then satisfy buyer to any manner, and the buyer's inspection advisory, which is a form we're going to look at. It's safer as the agent representing the buyer to go through the buyer inspection advisory form. And also there's a list called buyer inspection elections. And it has a list of like every kind of inspection or report you could ever think of ordering on the property. And the buyer can go through and mark the ones that they want and not mark the ones they don't want. It'll say, no, I don't want it. Now, the reason we sometimes go through the trouble to go through all that list of inspections and get the buyer to commit to which ones they want in writing is because, let's say the buyer moves in and there is something wrong with a piece of the property that was not inspected. And then the buyer is going to say, well, if you had told me I could have had a asbestos inspection, I would have had an asbestos inspection. You never told me that that even existed. If you had, I would have ordered it, and then I wouldn't be in this trouble. It's all your fault that I'm in this problem. It's a lot safer if you actually have the buyer sign a document that says, no, thank you, I don't want an asbestos inspection. Right, and so the buyer inspection advisory is included as part of the purchase contract. It's at the end, but the form buyer inspection elections, which I'll show you when we get to the zip forms, is something you'd like to maybe go through with them, just so they. And I've had people have radon gas inspections. I've had asbestos inspections done. I've had on 2 occasions. I had spiritual people come in to chase away evil spirits and ghosts. I'm not kidding. I am not kidding. So the buyer said we got this guy, we'd like him to come in and see if there's any evil spirits that drive them out. And I said, absolutely. Sounds like a wonderful idea to me. Go ahead and do it, right? So this is part of the process. The buyer should be really satisfied that they want to buy the house. The buyer, however, shall not make or cause to be made invasive, destructive investigations, and or are they to try to or inspections by any government. In other words, you're not supposed to call the city up and say, hey, I think this foundation doesn't look very good. Why don't you come out and look at it? And then they red tag it. This says you're not going to do that. The seller shall, right, make the property available for the investigations. Buyer shall, as specified in 14B, complete buyer investigations and either remove the contingency or cancel the agreement. Right. So within the 14B, which we're coming to, within that period of time, the buyer is supposed to have done all their inspections and decided, do they want to buy the house or not? They also are required to give the seller at no cost complete copies of all of this. I've had agents say, I know we're not going to give them a copy. We paid for it. They're ours. They're going to use it and they sell it to somebody else. The contract says you're supposed to do it. The seller is supposed to leave the water and lights and everything on so you can test it. And the buyer is going to indemnify the seller protection upon entry. So that means the buyer is not going to do something that would create a lien or do something that would cause damage without repairing it. And liability claims and demands, including workers' compensation. So if you've got somebody that let's say you know a contractor and you want the contractor to do the investigations, which they're sort of qualified to do, and they hurt themselves, are they covered by workers' compensation? Have you hired somebody to do something for which you should have covered them with workers' compensation? That's one of the reasons you might want to go with a company that's already got all that worked out. A notice of non-responsibility is something that you would record if you were the seller, if the buyer was actually having work done, which, by the way, you shouldn't be letting the buyer do except under weird circumstances. But it would mean that if the seller is not going to be responsible for a mechanics lien or something like that. Title investing. This is another contingency. So what that means is you get a preliminary title report. It doesn't necessarily contain everything. I've had transactions where the prelim didn't show anything wrong, but there was something wrong. The seller is supposed to give a copy of this within 7 days. Title is taken in its present condition, right? But subject to any encumbrances, restrictions, easements, and things like that. The opinion is offered title. I don't think the buyers, here it is. buyer's review of the preliminary title report and any other matters which may affect title are a contingency of this agreement. So I've had occasion to call, and they're called underwriters, the title company too, to ask them, you know, what is this? What's going on? Is there a problem? And it's also something you might want to look at yourself and ask questions. Now, one of the agents that I worked with, so she's representing the seller. The seller is selling a property to a buyer. And if you look at the preliminary title report, it says that the seller is the owner of the property. Right? It says that. It also just says normal stuff, right? There's property tax and utilities. There was a link in the prelim that you could click on and go and look at the grant deed. She did not do that. By the way, normally I didn't do that either. What turned out to be the case is that if you had clicked on the link and looked at the grant deed, that this property was bought like 30 years ago through one of the down payment assistance programs, one of the housing trust assistance programs. And if they gave you the money to buy the house, they oftentimes have rules about under what condition can the property be sold in the future, and to whom, and at what price. So when she called me and asked me about it, I said, my understanding is that after 20 some years, 21, I think it was, that you can do whatever you want. But let me look into it. And I learned then that there was a difference between the Silicon Valley Housing Trust and the Santa Clara County Housing Trust. And although one of them had a rule that said after so many years you could sell it and do whatever you wanted, the other one did not have that rule. It said you would always have to sell it in the future to somebody they had designated that was also part of the needy group to buy the house, and that you essentially were not allowed to make a profit. And it turns out that that was the one in this particular transaction that was involved. What that means is that they can't sell the house, right? You understand, because they just can't sell the house to that buyer. There's this defect, right? Now the buyer's agent didn't click on it and look at the deed. The title company hadn't looked at the deed at this point, but everything started to fall apart, right? You understand? So you ought to go through a class on how to read a prelim. You might be very curious. This is one of the things that I help people with, that I coach, is that I read through this stuff and help them figure it out. But the transaction all fell apart because the seller couldn't sell because of a restriction that was put in the deed. The seller has a duty to disclose all matters known to the seller affecting title. And then it says that you're going to get a grant deed. You could be a stock cooperative. That's a little weird. There's some of them in Santa Clara. The manner of taking title shall be, you should talk to a lawyer. And the title shall vest as designated in buyer's supplemental escrow instructions. So does the buyer need to know when they're writing the offer if they're going to take title as individuals, as a joint tenants, as a LLC, as a trust? Do they need to know that at the moment they're writing the offer? And the answer is no, not necessarily, because that's something that they could figure out during the escrow period. You're going to get buyer shall, right? Buyer shall receive a CLALTA homeowner's policy if applicable to the type of property and buyer. If not, escrow holder shall notify buyer. You're supposed to get title insurance, is what this says. And if you can't get title insurance, then that's a sort of a contingency, right? Because it says the buyer shall receive one. Now we're getting to the fun part, the time periods and removal of contingencies and cancellation rights. So the seller has 7 days or another number to deliver to buyer all reports, disclosures, and information. It would be better if they had done that in advance. it would be better. But if they haven't done it in advance, they have 7 days from the day the contract is accepted to provide all of those reports, disclosures, and information that the seller has. Then the buyer has 17 days, is what the default setting is. You could write in another number to complete buyer investigations, review disclosures, approve all matters of the property, and all that sort of stuff. All right. Now, let's say that the listing agent has given you a big package of stuff, right? There's a termite report, a property inspection, a preliminary title report, there's a copy of the homeowner association documents, there's a seller property questionnaire, there's the environmental hazards report, there's a statewide buyer and seller advisory, there's the Santa Clara County, San Mateo County advisory, there's market conditions advisory, there's like this huge stack of stuff. And on key pages, the listing agent has asked your client to initial or sign them, like on the first page of the termite report, the property inspection, you get the idea. And they want all of that back in advance or at the time you're making the offer. So let's say your buyer is given a copy of the termite report, given a copy of all those documents, and the buyer signs them and or initials and signs the reports and things like that, and then you give that back to the seller with your offer. Does that mean that you've accepted everything that's mentioned in those documents? Or does the buyer have a right to back out of the contract within this time period by reading more carefully the documents? Now, I've had many listing agents say, no, if you've signed the disclosure forms saying that you have received them and you do that before you make an offer, then you have constructive knowledge, right? You have knowledge of all the things that were included in those documents when you made the offer. You don't get any time. You can't back out because of something that you read. Now, one of the agents that I was coaching, the listing agent not only was telling her this, but the listing agent, in addition to being the listing agent, was an attorney. And so she called me and I had to talk with him. And the part that I emphasized is look at B1. Complete all buyer investigations. Now look what it says. Review all disclosures, reports, lease documents to be assumed by buyer, and other applicable information which buyer receives from seller, and approve all matters affecting the property. Review all these disclosures. So my wording of this is that my understanding of the wording of this is that if you have this contingency, an inspection contingency, if you have an inspection contingency, even though you've signed off on the termite report and the property inspection and you've signed all those other disclosures, that does not mean that you can't keep reading. And frankly, a lot of buyers end up writing an offer without having thoroughly read any of this stuff. And if push came to shove, I believe listing agents would lose because, you know, it says that you have this time to review these things and then approve all matters, right? Even though you got them in advance and even though you've signed them. Paragraph B2, buyer may request that seller make repairs or take any other action. So the property is being sold as is. Does that mean that the buyer can't ask the seller to fix stuff? Apparently not. It says here that you can ask the seller to fix stuff. Does the seller have to fix stuff? The answer is no, right? The seller does not have to make repairs. The buyer, however, would not have to buy the house either. And if you want the seller to make repairs, there's an RR form that is called a repair request form. And this is an interesting thing. The seller has no obligation to agree or respond. Huh? Isn't that's kind of snippy? So you could make a repair request form and send it to the seller and the listing agent, and they could just not do anything. Now, what's happening is the time period, right, is coming up. So what I suggest to agents is, let's say you have 17 days to put together your wish list, right? Your contingency remove before you do contingency removal. You have 17 days before day 16, right? Certainly before day 17, as really as soon as you can get it together, you want to come up with a list of things that the buyer doesn't like about the property and would like fixed or changed, and then communicate, typically by email, with the listing agent. By the way, as soon as I get copies of these reports, I send them to the listing agent. So they get to see them too. They get to see the $9,000 of Section 1 work, and that the property inspector thinks that the foundation crack is a serious thing. We want them to see it and read it and have some time to think about it. Because sometimes the seller is going through the different stages of grief. When reading and signing off on the disclosures and reports, when you are writing an offer, most of the time we'll have received and led and received and reviewed. Yes, so that does the fact that the listing agent typed that on the form mean that this contractual clause no longer takes effect, right? I doubt that, right? That obviates or cancels out the wording of the contract. And if the reality is these things go to arbitration, and is it likely, particularly in a multiple offer situation, that the buyer is being pressured to move quickly, not spend a lot of time thinking about it, not being given any time to do an inspection or review? And by the way, the sellers almost always lose when they go to arbitration if the buyer did not have a chance to do their own inspections and to have more time to review. You understand, once it goes to the arbitrator is not going to look at that thing that the listing agent typed that says read, read and reviewed, right? That's just like a stamp or something they put on. They're not going to take that and say, oh, well, now paragraph 14B1 doesn't apply anymore. That's not what happens. And the idea that sometimes that the buyers are being, rammed into this, railroaded into it, not given enough time to read everything. What does this mean then? If they don't have any time to read anything, right? I'm just saying. So yeah, people, I used to actually not only just said read, review, I would say read, reviewed, and accepted. But I also know that if this ever went to arbitration, they wouldn't care about that. So buyer consent, we want you to fix this stuff. Notice it says no obligation to agree or respond. You want to start this conversation before escrow is closing. So you send an email to the listing agent that says, here are the things the buyer would like you to fix. And they've already got a copy of the inspection report, so they know probably that this is coming. And then the seller is going to and by the way, it's more effective to get a credit than it is to get the seller to repair. And your loan agent might not want to see repair requests. Just saying, you might want to talk to your loan agent about how the loan agent and the lender feel about repair requests, because sometimes if you make it part of the contract, it means that there is something wrong with the property, which the lender is not going to like to hear. Right now, if the seller is giving the buyer $10,000 credit towards closing costs, that's what you write in. Seller to credit buyer $10,000 towards closing costs. Then that's different, right? Because they don't really, it's closing costs, whatever, it's a credit. But you need to be careful with these forms. So we want to start the discussion early. We want them to know what's wrong. We want them to have time to go through the stages of grief, denial, anger, and then pretty soon they get to acceptance and are willing to do something. By the end of the time period specified in 14B, Buyer shall deliver to seller a removal of the contingency or cancellation. However, if any document, disclosure, or information for which seller is responsible is not delivered, then the buyer has 5 days after delivery. So this is why we want everything done up front as much as possible. We don't want to be piecemealing it and coming up with other disclosures and filling out more forms. Continuation of the contingency, even after the end of the time period and before seller cancels, if at all, buyer retains the right in writing to either remove the contingencies or cancel the agreement. So let's say the contract says 17 days, it's day 18, day 19, day 20. Is the contract canceled? Are we all done? And that's not what this says. In order for the contract to be canceled, the seller is going, well, we're going to come to that. But sometimes it just keeps going on and on. Paragraph 14b5 is a surprise to some agents. The buyer shall have access to the property for 17 days after acceptance, whether or not there is an inspection contingency. Even if you make an offer non-contingent on the buyer's ability to do inspections, the buyer can still do inspections. That's what this paragraph says. Just that the result or acceptance of the inspections are not a contingency of the contract. So I've actually had listing agents say, well, no, you don't have an inspection contingency, so you can't have the property inspector come in. And you know what I spend time doing is doing screenshots of the contract and sending it to the other agent, right? You know, look at this, talk to your broker, right? But the buyer does have a right to inspect the property, even if there's no inspection contingency. The contingency just means that you're not connecting it to the buyer's right to cancel. There's a removal of contingency forms, which I'm going to be doing a class called counteroffers, contingencies, and more, and I'm going to go through that form there. Let's say the buyer is not removing the contingency. The buyer wants the seller to fix stuff, and the seller doesn't want to fix anything. It says the seller has the right to cancel if, by the time specified in the agreement, buyer does not deliver a contingency removal or cancellation, but seller, after first delivering the buyer a notice to perform, and the notice to perform gives them 2 days to do it. Now, if you're a listing agent and you want to put a little pressure, so let's say it's 2 days before the contingency is to be removed, the listing agent can give the buyer a notice to perform. And then what that would do is force them to do it on the day of the contingency removal. Let me explain what I mean. Well, let me just drop down here for a second. Notice a buyer to perform or seller that they should give the other party at least 2 days after delivery in order to perform. So let's say our contingency is for 17 days and day 17 has come and we haven't done anything. We represent the buyer. We haven't done anything. We're not done yet. We're still thinking about it. Well, on day 17, when the listing agent contacts us and said, hey, what are you doing? Are you going to remove your contingency or not? And we say we're still thinking about it. If they give us a notice to perform, we still have 2 more days. And if the notice to perform, that 2 days ends on a holiday or a weekend, it rolls over to the next day. So I've done this where the 2-day notice took us to Saturday, which meant we had till Monday in order to do this, right? You understand that you get an extra 2 days. Now, if the listing agent sees this coming and wants to pin you down, what they would do is 2 days before the 17 days has expired, they would give you the notice to perform. Because then if you don't perform on that day, the seller has a right to cancel. So after delivering the notice to the buyer perform, the seller, after delivering it, may cancel the agreement, right? Unless you've removed your contingencies. And deposits have to be returned. deposit funds. So what are the things that you might not have, the buyer might not have put in their deposit? So let's say the buyer has not put their deposit in within the 3 business days, or but whatever it says in the purchase contract, that would be covered. I'm going to do a whole class on the contingencies and the, on all this. It'll be coming up later. I've already talked about the notice to perform. It has to be done 2 days before. It can't be done more than 2 days before. It can only be done 2 days before. Notice of the buyer's removal, if they remove in writing, unless a buyer shall conclusively to have deemed to have completed their investigations, reviewed the reports, and elected to proceed with the transaction and assumed liability, responsibility, and expense for repairs or corrections. So once you remove think of the contingencies like escape hatches in a boat, right? Every time you remove a contingency, you closed and nailed shut one of the escape hatches. And when you removed all of your contingencies, there's none left. Close of escrow. What if the buyer can't close on time? The lender is, messing around. There's a notice to a demand to close escrow, a DCE form, and that gives them 3 days in order to close. There's more to say about that, but I don't know how much time do I have. Well, there's a lot of just boilerplate stuff coming up. Let me just say, so this is, what can the seller really do, right? And a lot of this depends upon the market, whether or not there's people standing in line to buy the listing. Let's say the listing has been on the market for a long time. Let's say that there aren't people waiting, they don't have backup offers. Essentially, if you're taking more time and the seller doesn't like it, the only thing the seller can do really is cancel the contract. Does the seller want to cancel the contract? And the answer is probably not. So you get into this situation where that's all they can really do to you. Do they really want to do it? Now, there's a certain limit as to how long they're going to let it go on, but I've had them go on for a month, right? Because my buyer was going to buy, we were having issues, and they really didn't want to put it back on the market, start all over again, start doing open houses, all that sort of thing. So there's a cancellation form, and there's instructions to cancel and release the deposits. And we're going to go through that later, but basically, if the seller says, we're not going to give you the deposit, let's say you've removed all your contingencies. You've removed all of your contingencies. You don't have any. And yet the buyer has found out something that they don't like about the property. And so the buyer says, I don't want to buy the property. Does that mean the buyer loses their deposit? Not necessarily. Because if the buyer cancels without a cause, it isn't an automatic forfeiture of the deposit. It's not like it's automatically given to the seller. The escrow company will not give the money to anyone unless one of 3 things occur. The buyer and seller sign a form. Now, your buyer is probably not going to want to sign a form that says they lose their deposit. I'm just saying, they probably won't want to sign that form. Number 2, arbitration orders the title company to do it, or number 3, a court does. And as long as this is still with the escrow company and has not been canceled, the listing agent is not going to be able to really put it on the market again, because the escrow company is not going to let them have 2 escrows. Plus, this contract hasn't been canceled. So for the seller to sell it to anyone else, the buyer has to sign the cancellation form. The buyer probably doesn't want to do that unless they get their money back. You see where I'm going with this? So I'm not saying no one ever loses their deposit. I'm just saying there's steps that are involved before anybody loses their deposit. Verification of condition. New agents call me up and they say, look, we're doing the walkthrough and I don't know what to say. I've been going through zip forms. I've looked really hard. I just don't know. I just don't get it. There's no walkthrough form, and so, yeah, we called it a walkthrough form. That's not the name of the form. The form is verification of condition. I would say type in condition or verification and, oh, there's the form. But this is what is called the walkthrough form. So the buyer shall have the right to make a final verification of the property within 5 days prior. They get to go walk through and see it. To make sure why, to make sure that things aren't broken, that things aren't missing, that sort of thing. Notice it says that this is not a contingency of the sale. So what happens if there's something broken or the buyer, there's personal property, there's debris, garbage left behind? What can the buyer do? And the answer is not too much. So what we can do is put a demand into escrow that they hold some money, not give it to the seller until it's done. That's one option. Another option is to not close the transaction because you don't like it. And number three, to close the transaction anyhow and take the seller to small claims court or just let it go. Repairs, if you're doing repairs, you should really think about that. They should be done after escrow closes, not during, if at all possible. Prorations of property taxes, I'm not going to get into that now because that's something that the title company will go over. Here we go, broker's compensation. Now we're getting to the good part. This just simply says that this is going to be part of the escrow instructions and that we're going to be paid, and it talks about the seller's, the buyer, the broker's duty, and it basically says we don't know anything, we don't decide what price the buyer shall pay, or the seller, we don't guarantee the condition, we don't know anything, we don't do anything. That's pretty much what this whole long paragraph says. Representative capacity is that if somebody's signing for a trust or an LLC or a corporation, there's another form to use. Paragraph 20 is something I rarely even read, but it's just a long thing about how this will be the beginning of escrow instructions. By the way, once this is accepted, the title company gets a copy of the purchase contract, and so does the loan agent, because this is the beginning of escrow instructions. Then we come to remedies for the buyer's breach. Now, liquidated damages basically says that if the buyer breaches, the buyer could lose the deposit paid. But if the property is anyhow no more than 3%, right? Because the California Civil Code says. Now, again, it's not an automatic forfeiture, right? The title company's not going to just make the decision the buyer breached and give it to the seller. It's way more complicated than that. There's mediation and arbitration. If I'm explaining this to clients, the way I explained it is mediation is like marriage counseling. Arbitration is divorce court, right? So the mediator can make suggestions, you don't have to follow them, but when you go to arbitration, it's binding. Now, in most counties in the Bay Area, certainly Santa Clara County, any kind of a dispute like this would go to arbitration anyhow. Any kind of a civil dispute like this would go to arbitration. The difference is that this is binding arbitration, which means you can't usually appeal it to a court if you don't like the decision. And by the way, the arbitrator is not required to follow the law or contract. The arbitrator can do whatever they think is right in this particular case. I'm just saying. The exception to this is if you go to small claims court. So any matter that is within the jurisdiction of a probate or small claims or bankruptcy court is exempted from this, and you can sue them in small claims court. Selection of service providers, the broker don't guarantee. We didn't pick them. Did we pick the title? Who? I don't know who picked all those people. Certainly wasn't me. And this basically says that it's not our fault if they turn out, crappy. The multiple listing service says we're going to tell the multiple listing service what happened. One of the questions that I get from buyers is, once escrow is closed, can I get Zillow and Redfin to remove the pictures? Can we take the pictures off the internet? Right, again, and it's just sort of, I don't know, naive to think that there's a way to get the pictures off the internet, right? You understand? I mean, really, you think, and first of all, that says that it's not going to be taken off the internet, And there's no way, write a letter, go ahead. I've actually had people say, well, I reached out to Zelle and they didn't even get back to me. Good luck with that. They're not going to take the pictures off the internet. Now, what do I want to do here? Time is of the essence is a clause that says that essence here is from a French word that means at the heart of the matter, which means you should extend contingencies rather than just let them lapse, because it says that time is of the essence at the heart of the matter. But if the listing agent allows the buyer to slide, then they can't later maybe decide that they're all going to take it seriously now. I'm going to go through the days and things like that in another class when we talk about contingencies and counteroffers. Expiration of offer. Here you need to write something in, right? And what you should write in where it says or by, put in your name, right? Put in your name. Because what this is saying is that acceptance is considered communicated when it has either been personally received by buyer or by you. And then the other thing to think about is whether or not they need 3 days. I'll talk in another class about how to present the offer, but you should have talked to the listing agent and asked them, how soon can you present the offer? And if he's like, well, they're hanging around, any night I can do it, don't give them 3 days. Notice where I get the 3 days from. Here it is. What you would do is put in another date. Give them 3. People don't need 3 days to decide if they like your price. They don't need 30 minutes, right? 3 minutes is probably too long. As soon as you say it, they probably know if they want to accept it or not. So you want to give people enough time that they can do it, but not so much time that they can shop your offer, because they might mention to other agents, hey, we got one, and this is what it's for. So then here's where your buyer signs. When it's accepted, if it's a counter offer, that's supposed to be checked. So in the counter offer, the seller is supposed to accept all of this, but then there would be an attached counter offer. Brokers are not parties to the agreement, right? We're not parties to the agreement. That's why there's this box around here, and it's just got our names on it, the names of the escrow holder. Here's the buyer inspection advisory, which would be a very good thing for you and your client to read. Consumer Privacy Act, read that if you have insomnia. And that's the end of the contract. So let's say we've done it in our handy zip forms software. And let's say our clients, this is the first time they've ever made an offer. And we're either, it's not convenient to go meet with them, or we're sheltering in place. I was showing a house, this is before the shelter in place rule. I was showing my listing and I said to the buyers, can you imagine yourselves being quarantined in this house? Oh, what is this? Anyhow, it's a new. So let's say we've, here's a residential purchase agreement and we want our buyer to sign it right now. All we're really doing is looking at this right now. And so what we would do is, what I do is I take now normally it doesn't say buying sample, it would say 233 Greenwood Drive, right? But I copy it because I'm incredibly lazy. And then I would go to e-signatures and see that little dot, and then I would paste that in. So it would say 233 Greenwood Drive. You can add other documents. Digital ink is free. Well, nothing is free with the Association of Realtors, but it's provided at no additional charge. It'll work just fine. If you want DocuSign, you have to pay for it. We go to next, and then these are, and let's say I didn't really put in buyers or that sort of thing because this was just a sample. But what you want is usually, let's say there's 2 buyers. One of them is an obvious decision maker. So you send it to that one first. It's possible, it's okay that the email address you use for the two buyers is the same email address, right? If they say, can we use the same email address? Sure, why not? Right, it generates two emails. So you send it to the decision maker first. So the decision maker gets a chance to look at it. Then it goes to the second buyer if there's a second buyer. And then it goes to you, right? Those are the three that should be checked because there's places for you to sign as well. And then you could go through, I'm just closing this because we really don't have anything to sign, and you just go through the process and you send it to them. All right, so now our offer is on the way for them to sign electronically, but we're going to need to explain it to them. Now, you may have heard of software like Zoom. Skype actually has a new product that's also free. You don't have to download anything. There's Google Meetings. There's a bunch of them. And there's also something actually built in to your Zip Forms account, which is up here, which is something that most agents have never, clicked on. But we're going to go where few agents have gone before. And we click on it. And this is done by a company called Any Meeting. And you can add participants. So the people that you can find in your database, so the buyer's name, that sort of thing, you can put in, you can find it from your address book. You could add them manually. You can add them, and then you can launch a meeting. And when you do that, it's going to have like what I'm doing here, right? Without you actually having to do anything. Advanced options, have I looked at that recently? So I could schedule, they wanted to know if I have any questions, not really. I could schedule the meeting. There could be recordings of meetings that I've done, but I think you have to pay for that. So Zoom, there are other ways of doing it, but I'm just saying at that point, what happened to it? At that point, a meeting would occur and you could share your screen or they could share their screen. And so sometimes what I do is if I'm doing that and we haven't gone through this process before, I would create the meeting and I would be sharing the screen as I filled out the purchase agreement. I was a little more in detail, unless the people have a lot of questions with you guys than I would with a client, but I would be going through it and explaining it along the way. And when done, hit send to them, and then they assign electronically and it comes back. If they've made offers before, they generally don't want to hear about it. Just, this is the price, this is how many days we need, this is the contingencies we want, send it, let's sign, let's get going, and so you don't necessarily have to go through it. But your ability, by the way, and I was doing this before anybody really heard of the coronavirus, but your ability to be able to do this remotely, I think, is an important thing for you to be able to do. Because even if the shelter in place is over, that means we're going to have traffic again, right? And you getting in your car and driving across town at the wrong time just to sit down with people and go through a form and have the manual, that's really old. This would be a better way. Now, if your clients are not very sophisticated, then you might have to actually, physically go there and do it. But I'm just saying. It wouldn't hurt to give your clients a sample. If you go up to print, one of the things is print a sample and to give them a sample of the form once you've done your buyer consultation so they could read it in advance and make up a list of questions that they might have so that when it comes time to sign it, it isn't like a shock to them. Like, what is this? Oh my God, it's so long. I don't even know what this means. I wish I had time to think about it. Right, you could avoid that. Well, anyhow, that's it for this series. I hope you found this fun, if that's really the right word for it. But next week, we're going to talk about the listing agreement, I believe, and onward and upward from there. Well, be safe, stay healthy. I look forward to seeing you in the future.